Good morning, good morning, good morning. It is Wednesday, it's November 13th. There is much time this morning because, well, words, Emily, we are going to court this morning together. So there is lots to do. That just turned into much time. So I feel like what I should be saying is, hear ye, law nerds of the chat and the replay crew. We love you. Don't worry, the timestamps will all be down below. We are going to court. There is a pretrial motions in the Karen Reed case today. We have seen on the docket motions for a continuance that's stipulated. It doesn't mean it will be granted. It should be, but it doesn't mean that it will be granted. So there are motions, stipulated motion to continue. Then there are a bunch of discovery motions from both sides, the prosecution and the defense. This is the first time we're going to see the new special prosecutor in court. They are likely going to be not in the court we saw trial in. That wasn't Judge Cannoni's regular court. We're going to be back in regular court. So we are not going to be in the Supreme Judicial Court today. They have not ruled yet. We're not going to be in the court where the trial was because, they're not in trial anymore. We're going to be back in the home court for Judge Cannoni, and we're going to sit and watch the proceedings as they unfold. We're just going to breakfast together. Look, I have cold medicine, I have coffee, I have a muffin, because okay, muffin. And that's about all we can do this morning. I am under the weather. You're going to absolutely hear it in my voice. Don't worry. We've got an entire box of Kleenex. It's all going to be good. So for those of you asking if I'm feeling better, I'm happy to be in court today. And if it is a long day, then you're going to see how that goes. My eyes will not stop watering. But we're going to just roll to court. So I imagine they're going to get through multiple motions today. I will be curious to see their arguments on the discovery motions. I imagine this judge is going to give them a little pushback on the motion to continue, but we will see. I'm not quite sure. So let us get rolling. I saw somebody say every YouTuber I watch this week is sick. It's just that time of year. My kiddos were sick, and then I got the standard delay enough that there was hope, and I was like, okay, we're good. And then wham. So enough that there was hope, and then not so much.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Perfect.
For tickets to inauguration 2020.
And now we get the hear ye's.
All persons have any business before the Honorable Beverly Cannoni, Justice of
You are unmuted.
And for the County of Norfolk. God near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, Commonwealth versus Karen Reed. Can I have the Commonwealth identify themselves?
I will say the camera today is crisp as can be. Crisp as can be.
For the record.
Good morning, Your Honor. My name is Hank Brennan. I've been appointed as a special prosecutor for the Commonwealth.
Well, that's
along
new.
with me is attorney Laura McLaughlin.
Hello, Mr. Brennan.
And attorney Adam Lally.
Good morning, Mr.
morning.
Brennan. Good morning, Mr. Lally.
Good morning, Your Honor.
Good morning, Ms. McLaughlin.
For the defense?
Good morning, Your Honor. Alan Jackson on behalf of Ms.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion
discovery motions
for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these?
These are motions for Verizon.
Pursuant to Rule 17.
Thank you.
So these are motions for Verizon. They are trying to get to Karen Reed's father's cell phone records and the Verizon cell phone records. So that's what they're trying to do. Some of you are saying that the audio has started crackling again. I don't know if there is much else we can do. Let me try. Let me see if that will help, and let's keep rolling.
Your Honor, I understand the court might have a preference that I remove from the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm
fine.
sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Okay.
So I have filed these just to give everybody as much notice as possible, and my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Okay. All right, so I misunderstood. I thought they were on for the Rule 17 motions today. All right, so the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later, to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences.
I talk about this in this week's podcast. For those of you that are just tuning back into Karen Reed, Adam Lally is no longer the lead prosecutor. Mr. Brennan is the special prosecutor. They are trying to get to, are we doing these Rule 17 or these discovery motions now? And they said, no, I didn't want to be presumptuous. I wanted to make sure that we could get to the records. There's been some objections. He's trying to ask permission rather than forgiveness with this court. I think that is wise from everything we've seen in this case. But the next motions are regarding the sidebars. And the judge has, in fact, impounded or sealed the sidebars. Why do they call it being impounded in Massachusetts? I don't know. But instead of saying it's sealed, they say it's impounded, like you're in trouble. So it is impounded, but we can't get the sidebars. They are not part of the record. Those are all under seal. And the defense is asking for relief from that. So we're going to hear the defense asking for relief from the sidebars being sealed. And we're going to go to that now. I mentioned it again. The podcast will be out today. For those of you like, did I miss anything with the podcast? No. Other than me struggle busing through it, we did not do it behind the scenes this week because the struggle bus is real. But we are going to move forward with that. Let's go.
Before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all of the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right. Why don't you? All right, Mr. Yannetti, do you want to be heard by starting with the whole motion, or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because unlike...
Damn it. I want... Bring the sidebars. But the fact that even counsel can't see them is a huge issue. Counsel can't see the sidebars. Counsel... what? So with counsel not being able to see the sidebars, yes, Mr. Brennan is at a huge disadvantage. Big, huge, massive. The fact that the attorneys can't see the sidebars is the stupidest thing I've ever heard. Emily, you're sick. Do you ever call things stupid? Really rarely. But this is dumb. This is a dumb ruling, and I hate it. Why would they do that?
He was not present at sidebar. He does not know what the conferences were about.
Wild.
And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms.
Your Honor, you don't need to eat the microphone, Your Honor. Your Honor. For all of you saying, why are the sidebars impounded? I have no idea. Who made that ruling? This judge. Why did she make that ruling? I don't know. I cannot, and I have learned in this case, I cannot even begin to speculate on why this judge does the things the way that she does them. I do not know. I do not understand. I do not know. I don't think, for those of you being like, why does this judge already have an edit? I think it's just her. I think this is her affect. I've not watched her in another case. I think this is just her affect. Look, I miss Judge K, okay? I miss Judge K. I'm in mourning. I feel like we've been broken up with and we've been shipped back to a substitute teacher that we all don't really like that much. And I feel you. I feel you. I hate this ruling, but we'll see. The fact that the attorneys can't have them, though, is silly.
How long it will take to get these transcripts?
My co-counsel has spoken to her only...
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that?
Why does it matter which co-counsel? Why does it matter which co-counsel? Which co-counsel, Mr. Jackson? Fine.
And how quickly can she get them?
She works extremely expeditiously, but she has not started them, to my understanding. There's 3 reporters who probably would split the work, and she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or 2. I think we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the...
That's the feed.
With the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to jurors.
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them. If I have any...
You can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside of protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful,
I think that's fair.
Would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point.
I think that's
All
fair.
the other information, I don't have the same concern.
Okay. All right. Thank you. All right, the next motion.
I think that's fair.
So defendant's motion for discovery of communications in the possession.
So what it seems that they decided as they are moving right through is that the transcripts sidebars will be unsealed. They are going to allow counsel to review them. I don't think the public's going to be able to get those, even if they request a transcript at this point. But at a minimum, all of the sidebars with jurors, anything to do with the jurors, any conversation with the jurors, that is all going to remain impounded. The attorneys can have access to it, but no one else. I think at this point with the pending appeal, that's fair. I think an abundance of caution with the jurors is where I'm most comfortable as well. So,
Possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard
Okay,
at
so we're
that
just
time.
bumping
But I'm
stuff.
prepared now if the court prefers me to
Well,
argue.
I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
So we're just bumping stuff down.
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to.
Okay.
So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay.
Okay. They're all in agreement on that?
So why don't we give you...
Kick it down the road to another date. All right. Another
give you
date.
until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right, does that work for you, Ms. Giannetti?
Certainly does.
Okay.
All right, so let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
Yes, let's. So, here's the tea. The Commonwealth, remember all their experts from the Commonwealth? And the experts ripped apart all the telematics systems from the Lexus SUV to try to get any information about Karen Reed driving that evening, backing up that evening, if there had been a collision that evening. And the dude didn't know how to get some of the information out of the Lexus and was like, here's my summary of the testimony. Like, I watched some YouTube videos and I couldn't get the information out. It is probably more technical than that. And some of it was, we didn't have the software to download stuff out of the Lexus system because we couldn't get to like the black box of the system and whatever. Now the Commonwealth has given notice that they are going to reassemble the telematics system. Sorry, that was completely me. Reassemble the telematics system to try to, I don't know, get a go at it again with a different expert, because we've seen filings from the Commonwealth in that motion to continue where they have a fleet of new experts. Are we surprised they want new experts? Is anyone surprised? A fleet of new experts. So now they're going to reassemble the telematics system that they had taken all apart and try to get information out of it. And the defense is like, what we're not doing. So the defense is arguing against this. I imagine it's because, Your Honor, how do we even know that they can get information out of it if it's reassembled? We're going to see. I haven't covered those written motions, but we're going to go through it now together and see what the state has to say, because they want to reassemble the electrical technical components of the Lexus that was taken apart.
May I?
Yes.
As a matter of background, as I think the court is likely aware,
We're aware.
the Commonwealth tested information on data chips that were
Oh,
found
we know.
in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader. So that way the information...
Are we surprised? Raise your hand in the chat if you're surprised that the chips that were removed from the system were read with the wrong reader. Who's dying of not surprised?
Was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather
Well, they
it was
don't
to
need
notice
permission.
them this is what we were going to do.
They do need to notice. I think that's fair. They don't need the defense's blessing to go ahead and test it. But I do think it is fair, and I think in this case needed, to say, we are going to have our expert test this data. Would you like your expert to be present so your expert also has a copy of the data, et cetera, et cetera? So I think giving the defense a heads up at every stage of the proceedings at this point is necessary. Sorry, my finger was ready to keep going in court, but I do appreciate the transparency at this very, very, very late stage.
Permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize the Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it.
They can't prevent
so that's
it.
why I agreed to this date.
I'm saving y'all's questions so we get to
we
Q&A.
know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them.
Because the expert had no idea how to work on the Toyota Lexus proprietary infotainment system, telematics system. But a good expert would say, I don't work on these systems. You need an expert that works on these particular cars.
And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today.
They're trying to contest
but I would
it.
say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably,
Their expert should get a download.
When the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested. And it was
that's
the expert that overlooked the fact that there was 3 panels in the system, not 2. And
when dealing with experts in a case where you're accusing someone of doing a thing, you should have your experts do it. I am very interested in why they're like, well, the defense expert missed this and this and that. When their expert stood on the stand, I take a little issue. Their expert sat on the stand and was like, I don't know how to do this. Oh, boy.
And our expert was astute enough to find those oversights, and that's why we
At what
have
point?
an independent expert that is going to do this. I know experts differ. We are not frick or frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th.
Well, there's a motion
So all of
pending
these
today.
things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, 'cause it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay.
Nishay, I've got
Mr.
your question. It's a
Jackson.
good question.
Thank you, Your Honor.
Sorry, Mr.
I'll
Jackson.
start by saying
I apologize in advance for the thirst over the beard. Chat loves a beard 90% of the time. So it just is. And we're all still mourning the fact that we don't have court today with Judge K. However, don't worry, we have some court for Corey Richins, and we love that judge's beard as well. So chat, don't worry, we will be back in the hands of the judges that we love. But I think it's fair of Judge Bev. Look, if I'm going to be critical of Judge C, then we're going to be fair. It's fair of her to be like, what are we doing though? Why are we having a motion to have a motion about a motion that we're going to have a motion? Like, can we just do the thing while we're in court? What are we doing? And the prosecution is like, I wanted to give everyone the heads up because I don't want it to bite me in the ass. That's my summary. And the defense is like, no, we're not doing this. I can't wait to hear where the defense is going with this after their expert was just thrown under the bus.
in principle, we don't have an objection to the retesting of the telematics or the infotainment center or system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, the Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And
chips.
you have a different expert now.
I mean, 10 points to Gryffindor for the use of the word facile. Also, I love that he's like, let me just tell you how all this went down, is that their expert was like, I don't know how to do this, and looked at our expert and was like, do you know how to do this? And then their expert was like, I mean, sure. But their expert had been MSP as well, which is interesting.
Oh, you're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure.
If you fuck it up, you're fucked.
He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to...
Yes, well, this fine Commonwealth of Massachusetts doesn't make it easy for everyone to read it. So thank you, Alan Jackson, for bringing us all up to speed, because it is not easy to get all of the motions if you are not actually in the state of Massachusetts or the Commonwealth of Massachusetts. But she's like, I've read it. Look, I appreciate that you guys keep the same energy when they were getting cut off in by the Court of Appeals. It feels weird, but this is not just this judge. This is judge after judge with I've read this. Can we move on? The Supreme Judicial Court did it with the attorneys. We saw it in Idaho as well with the you don't need to reiterate to me your motion. So we've seen it with judge after judge after judge. So please do not, well, you guys can judge how you want, but it is something that we've seen with judge after judge of different things that we've covered. So I appreciate Jackson bringing us all up to speed with that, because honestly, I want to hear it.
Sort of engages in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits.
They have an issue with the expert.
Gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips. That didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123
I appreciate that he lets us know it's a hypo.
bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read,
but I don't want you to fuck it up,
or
right?
In peril of being destroyed. That's all.
Sometimes destructive testing happens.
Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He would be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing.
That sounds a little different than what we heard from Trooper Paul, but I don't think that expert was experty. So again, the defense is like, we want our expert to be there. Their expert has a right, well, not always a right to be there. They're making sure their expert has the opportunity to be there and making sure that that opportunity is not interfering with the testing from the Commonwealth's expert. But I think in this case, it is fair that the defense expert should be there and the process should be observed, because when it gets to trial, depending on what the data is that comes off, there's going to be a back and forth about it. So I think that's fair.
The defense is not entitled to veto power during the process. That will delay things. It has no role or no purpose in it. And so
they get to
inevitably,
observe.
Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these ships and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It will provide the information that will be available to both us and the defense.
It'll be interesting to
If I
see.
act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence, and I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule.
Good luck with
So
that.
I can't give an exact date because that conversation wasn't what I was expecting, but I don't think
Yeah,
we can tolerate waiting that long.
That seems like an understatement.
All right, this one I will act on very quickly.
Oh,
All
you're not
right,
ruling today.
So I think that just leaves us with the motion to...
You know, Your Honor, in Utah, he just like throws it down from the bench. You can, Your Honor, you can rule on that. You can rule on that now. You can. This judge is never going to rule from the bench. It's just not going to happen.
To continue, I know it's a joint motion, but I need to hear from both sides as to why I should do that.
This is regarding the continuance.
Brennan?
Can I begin?
Yes. And the request is for
That
the
wasn't me.
April 1st date. You're not looking to go any further than that.
Now the sigh is me. That original breath was not me. Now the breath is me. The Corey Richins case is starting in May. I am very much wanting to see this case. If they start this case in April, we are going to be back to back to back with trials during, and maybe overlapping with trials. Unless this one goes substantially faster.
Correct?
We are not. We are not.
I don't see her denying this
The Commonwealth has
motion.
been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective
keeps
is
saying
to
that.
move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible.
Not to cut you off, counsel, but to absolutely cut you off. He is trying to speak Judge Bev's love language, which is this will be a smoother, faster, better trial, Your Honor. We're not going to ask every witness if it was snowing. We're not going to ask every witness where they were sitting at the fucking basketball game. We're not going to ask every witness if it was a high top table. The presentation of evidence will be streamlined, Your Honor. It's going to be version, 2.0. It's going to be better. Please give us more time so we can do it better, faster, all. So that is what counsel is advocating for.
The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to
There's
the
a lot of
defense.
new experts.
The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th.
She's denied
However,
continuances
I realized when I
before.
was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony they're retaining experts to counter that testimony and then to reciprocate in discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided.
Are you
but it
determining
wasn't
why this
base
case is
numbers,
being
which I'm
tried
accustomed
again?
to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will
I think that's
resolve
appropriate
or
and
prevent
diligent.
any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the
Should
office,
happen.
have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as
I appreciate the transparency. I think that's how it should be. Because again, if you turn something over to the defense that's not discoverable for any reason, then the defense just, you argue if they try to use it down the road, that's it. I think being overly forthcoming is how all prosecution offices should be. There should be no surprise. There should be an incredible amount of transparency. And again, that was my habit and practice and that of my colleagues. It surprises me. The more I watch court around the country, the more surprised I am of like, wait, y'all are doing what now? The way that I am shocked, because again, that wouldn't fly in the office that I worked in and with the culture of the other prosecutors I worked with. When everyone in your office is like, that's not how you do it, you don't do it that way. So the overabundance of caution, turning everything over at the outset. And then if the defense is like, well, we want to use that, and you're like, actually, you can't use that in trial, then you make the motions later, but you turn it all over to the point that we would sit down with defense attorneys and like all of the bosses, and of which, depending on the office, there are many, many, many bosses, but sit down and talk about why charging decisions were made, why decisions were made versus plea deals and not made, and bring them in to the thought process where appropriate. There should be transparency. It's the only way that it works right. So I appreciate that he's like, look, I don't wait till the expert reports are done. When I get it, it turns over, including, he said, did you hear what he said? Including emails from the public with theories I don't even agree about that get turned over. If anyone is emailing anyone involved in this case, at some point it's going to end up in a FOIA request. Everything is going to come out. Just like we saw with Courthouse Becky's emails, there were people all up in her emails. She's giving out jurors' phone numbers. She's asking for phone numbers in the Murdaugh case. She's getting, Nancy Grace's phone number. Hopefully it's a work cell phone number in her emails. It like everything was in there, and all of it came out because Courthouse Becky was using her work email for all of it. And those emails are subject to Freedom of Information Act. So, all of it's going to come out. I'm not surprised that members of the public are emailing all the time to both this special prosecutor, to the defense, to the rest of it. We're going to see it. So just know that we're going to see all of it. We're going to see all of it come out at some point. We'll go over it at some point. Is that now? No, but we'll see all of it at some point. But I appreciate the abundance of transparency. It's the way that it should be. Again, I think that I am benefited and hindered by the fact that I worked at a very large office that kind of set some of the standards for the country in prosecution just because of the benefit of a large office, but also incredible attorneys. And I benefited from that, but I'm also hindered by that because there's times that it's like the prosecutors did this. I'm like, wait, what? And then we cover these cases elsewhere and I'm like, wait, what? I am continuously stunned at how some of these cases go. Carrie Morrissey. So I hope this special prosecutor is more special. And I love the transparency. So for me, that's special. Look, man, it's not supposed to be a game of hide the ball at all.
To avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially.
Yay!
And so, although it
Wait a
does delay
second.
the case,
Wait
if
a
you allow
second.
this motion,
Wait a second. We're rewinding that real quick. We need the instant playback. What did you just say?
which I'm still in the process of doing, of reducing the witness list substantially.
Reducing the witness list substantially. Sir, hold on. You're getting some applause. Where is it? Well done, sir. Well done, sir. Look, as much as I enjoyed the colloquethesis, I don't know if that was what you would call necessary testimony. But yes, the witness list should be culled substantially. Substantially. And I saw a few questions for those of you that are new to my stream. Hi, it's a commentary channel. If you just want to watch the court without the commentary, there are plenty of channels that just roll court. I am not one of them. We are hyperverbal over here. All right, let us continue culling the witness list substantially. Thank God.
And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of
That's on us.
or that I would like,
That's on
I
you.
appreciate I won't be able to use that expert. And so I think the
Fair.
joint request is something that is legitimate. I think it's well thought, and I leave it to your honor. Thank you.
How do you think the conversations with him and Lally go? How do you think the conversations between him and Lally go? I think it will be a shorter trial, a more efficient trial, and a more fair trial for everyone. So, you think he and Lally get along, chat, or not?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly wants to...
I appreciate that counsel, I think, again, everyone wants a fair trial, right? The defense has two options in this. The defense could say, no, fuck you, go to trial again. The defense, I think, is well prepared for what this trial looks like a second time. I think they'll make more motions to block things. I think they will really be on the better foot going forward. I think their experts were great, but I also appreciate that if they allow for the witness list to be culled, if they allow for new experts, the case might get better for them, but also it allows time for the Supreme Judicial Court to rule. It's very clear that Judge Cannoni is not going to give them time to wait on what the SJC does. Also, it is the very outside chance that the SJC even allows the jurors to be spoken with. I wonder if the defense's best play in their conversations together is to allow the new experts to come in and then to advocate to the new special prosecutor to cull down the amount of counts. And if the Supreme Judicial Court allows for the interview of the jurors, then to really advocate to the new special prosecutor, can we just go to trial on count 2? and really try to get the prosecution, who's really, I think, the only one in the lawful position to get rid of counts 1 and counts 3, to then advocate to narrow it down with them and go to trial just on count 2 and its subcounts. So I think that that's why the defense is not trying to really, put the screws to the prosecution and make them go to trial next month. I think everyone wants more time. Much easier for the defense to advocate for when their client's out of custody. This becomes a much harder argument if there is a client in custody who's like, I want to get out of custody. I want to get out of custody. And we saw how that played out in the YSL case. And on the podcast that'll drop later today on the channel, you'll hear other defendants that want to get out of custody, Diddy again and Corey Richens. Karen Reed is out of custody. And though she's in a holding pattern, it's better to do it right sometimes than to do it fast.
Testing is complete. Disclosures are made. We would have the right
sounds like I do.
To consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that, though, in anticipation?
We have.
Okay.
Yes.
Of course they have.
Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as the trial was ongoing.
Which is awful because it still took like 2 years for this to go to trial, less than 2 years for this to go to trial. The fact that discovery wasn't indexed is just, don't ever do that. What is that? You can never be sure, especially in a murder case, that everything's been turned over if it's not indexed and Bates stamped. Like what are we doing? Also, I think, or I wonder if because Brennan is also a defense attorney, if Brennan and Yannetti before this had at least collegial working relationship, and that Yannetti feels that maybe Brennan's lens of fairness is the lens of a defense attorney first saying, this is what I want to see. Kit Gracie in the chat asked, what is indexing? Indexing or Bates stamping is being like, okay, this is page 1, this is page 2. It's making sure that there is a stamp for everything. So the defense can be like, hey, we're missing page 335 or whatever. And you go through everything. It is time consuming, but you index everything with a number and make sure that the defense has every single number and you have every single number. It is best practice. It should start at the beginning. And oftentimes it's the work of the prosecutor. Oftentimes prosecutors don't have assistants to help with that. They are the ones doing it themselves. But when it comes from law enforcement to the prosecutor needs to make sure everything's indexed instead of just writing a note and being like, we turned over CD number 7. You need to note CD number 7 contains this, was turned over on this day, and it needs to be stamped. It is the only way with a lot of discovery to make sure nothing's missing. But you've seen what happens when discovery is not turned over in the Alec Baldwin case. It is one of the most weighty obligations of a prosecutor, because if you don't turn stuff over, even if it's by mistake, your case can still get yeeted. And we've seen that. So it is best practices. It is time consuming. Oftentimes prosecutors are doing it themselves because they don't have paralegals. But it seems that there was help in this case, that Adam Lally wasn't doing everything himself. So it should have been done. I appreciate that it's getting done now.
Sometimes deep into a trial, and we're really trying to avoid that.
I'm holding on to your guys' questions.
It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial.
And that's what's fair.
I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow
We're all on the
this
same page here, Your Honor.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have.
So how many more
we need to
pretrial
start
hearings?
Moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing?
Daubert hearing is going to be regarding the experts. So do we need to have a hearing about whether the experts can come in? It's going to start all over, right? What pretrial hearings do we need to have? Discovery hearings, expert hearings, motions in limine. What other hearings do we need?
I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called a expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert I did not.
Forgive me, I haven't watched all the trial. You have, sir, the incredible blessing that this was streamed so he can go back, not mine, I paused too much, but he can go back and literally watch the entirety of the trial and only go to the transcripts for the sidebar. It's an incredible benefit to be able to watch it as opposed to sitting down and reading 7-8 weeks of transcripts, which would make anybody's eyeballs cross. So the benefit of being able to rewatch it is pretty incredible.
Probably followed the proper methodology or had the expertise to make.
All right, does the defense intend to call Dr., I've forgotten her name.
Yes.
Dr. Russell.
Dr.
Russell,
Dogbite.
do you intend to call her again?
I expect that she will be out on this list.
All right, so why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It
Oh,
does,
we're
Your
going to
Honor.
get more hearings.
So why don't we set a
Okay.
Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule
motion?
17 we're doing as soon as possible. We'll do before that date.
Understood.
Yep. So, yep. The answer is yep. Which is hard because they need to talk about the different hearings.
So we're going to need.
Excuse me, we do, look, I don't know what just happened with the camera. Karen Reed is always well-dressed in court. I appreciate it, but we don't need the extreme zoom.
Maybe we can have
Look, everybody's hair looks good. We're good. I just want to look at them picking dates.
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Charlie, it's good to see you in the chat. No, Karen Reed is not in custody. Karen Reed has been out on bail. She was in custody, I think, just overnight on the second arrest. She's been arrested a couple times, but she is been out on bail and will remain out on bail.
December be available for a Daubert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be
works.
time consuming.
Half of being a lawyer is, in fact, picking
I could
dates.
also do the 12th if Mr. Brennan's available, and in my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th?
Literally half of lawyering is picking dates.
The government's available on the 10th.
So I have a, you cannot do the 10th, okay.
Do you see everybody with their phones out? Literally. I'll tell stories later.
Your Honor, just to be completely candid, I have nothing on the 10th, but I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th, and I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
Well, court
fly on the 10th.
Mr. Jackson, you don't have a private jet. I'm teasing. Only Girardi of all the attorneys I've ever known had a private jet. But yes, getting from LA in court all day to LAX to catch a flight, to get to Massachusetts for a hearing the next morning would be quite difficult. What do you mean you can't time travel, Mr. Jackson? What? Weren't you a helicopter mechanic? Can't you get somebody to just chopper you across? I'm teasing. He's like, no, Delta One only. I know the flights between LA and Boston. There's no flight out of LAX until this time, and we're only flying Delta One, Your Honor. That's what's happening.
Time.
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
But he's not going to be able to get to the airport in time.
The evening of the night?
Can't you just take a red eye? He's like, I do every time.
Back in California, so I can't fly that day.
So she's like,
Court ends at what time?
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
I'm sure he does,
You
actually.
can't fly out on the 9th, the evening of the night?
There's no way I can't take a flight on the 9th.
What about the 6th?
Your Honor, have you ever driven in Los Angeles? Look, it's like driving around Boston during the Big Dig, but worse. There is no way you're getting from court in downtown Los Angeles to hop on a flight at LAX with a dream and a cardigan. You're not getting there. There's just not a chance. And you're not getting a red eye out of Burbank, Your Honor. Okay, so one of the judges that I used to appear in front of was like one of those million-miler flyers who like flew all the time. And his level of neurospicy was flights, planes, and flight schedules. So when jurors would come in and like, I have a flight booked, he's like, which airport? Which airline? Oh, is it this one, or this one? He knew every flight schedule for literally everything. It was absolutely amazing. Listening to this man talk about flying was absolutely a joy because he loved travel, he loved flying, and he knew everything about every flight. And he would have been like, well, Mr. Jackson, actually, Delta flies out of LAX to Boston at this time. Judge Bev does not have that benefit.
16th, it's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. Jim, we just put Gaston on for that day. Yep, we have a full competency hearing, and we also do on Gaston.
They've already charged changing judge in this case. It was denied, so no. This judge is specially assigned to this case, and that is it.
Let me just look at that. Did you say the 12th?
The 12th works for me.
Danielle, I've almost missed flights out of LAX with 3 hours. With 3 hours
We'll
lead time.
accommodate, yes.
All right, so the Darbert hearing will be December 12th.
Yay!
Be at 9 o'clock, Your Honor?
All that conversation to get back to the date that they originally said. December 12th at 9 a.m. I'm going to start putting shit on my calendar.
And those motions should be filed on the 27th.
Oh, that's early. Can we do 10? I like 10 better.
We'll get a date on that in just a minute, Jimmy.
Judges are normally assigned by random, Bernie, so they are normally assigned by random.
When are you available for the Rule 17 motions? How about November 26th?
I really wanted to be off that week, but I mean, okay. AJ's like, I really don't want to fly to Massachusetts.
In Woburn District Court. To the extent that the court would give me a protective order, I think.
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
We're not a trial here, but this motion.
Yeah, you can't say you have a
I'd like to
trial.
do it as soon as possible to get those out and get that moving.
Thank you.
That's
So
hard.
November 26th, Jim, can we do
All
that in the
right, I
morning?
guess we're doing that.
Okay.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
She's like, do we need you? The chat says yes. The chat says yes, we absolutely need AJ. But it is going to be hard at the holidays to find court dates. There are lots of dates that court is
During this
closed.
moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of...
File it and send notice immediately of the date.
I will.
She's like, can we just do it all?
Do I send notice on behalf of the Commonwealth, or does the clerk's office send it?
Mr. Lally can inform you on the process, but
Thank you very
you
much.
send it right out. And
We will.
Okay.
Thank you.
Is that okay?
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
I likely will not be here, but
Okay.
She's like, all right, fine.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m.
Get all the record holders who want to be here.
Woohoo! Oh, well, I guess that feed just ended while they were still picking dates. I'm going to go look and see if another feed has the rest of them picking dates. I hate it when the media does that. They're like, this isn't important. Actually, it is important. So it looks like November 26th and December 12th. Let me switch real quick and see if there was anything that had a little more at the end of that feed. Miguelina, if you don't mind putting in that other feed that we had, I will double check. Let's see. I love that it's like, oh, Emily's video is at the end of Emily's video. And Emily's still live. Why won't this let me type? Let me be great. What are you doing? All right. Let's see if we have any more discussion about that. Thank you, Miguelina. I appreciate that. Let's see if we can get to the end of this hearing. And yes, perfect. Miguelina, you are the best. I need a huge thank you from the chat to Team Baker. Look, I have not been feeling well, so I am slow in getting things done. Also, my brain is not nearly as concise. Team Baker did all of the things. So Dan and Miguelina and Jordan made sure that not only do we have a podcast for you coming out later today, but that we could do this morning. Thank you to the mod team for being flexible and making sure not only that we had a stream today, but that we can stream tomorrow. I'm going to try. I am working very hard to get you video from the Corey Richens hearing from yesterday. So thank you to the team. The team in the back end is working on Law Nerd Shop 2.0, making sure that we are ready to roll into lots of trial coverage in 2025. And I am just incredible. Well, I'm going to get all weepy because I'm sick and I get all sappy, but I am just incredibly grateful for this incredible team and how patient they are even when I'm not feeling well, and how dedicated they are to be like, no, we're going to get this done and we're going to get this out to the law nerds. We're going to make it happen no matter what. I truly incredibly grateful. And to all of you that are like, girl, we're with you. We know there's tech issues the way we are building out something new. We know there's tech issues. We've got it. For everyone who's going to watch the replay and be frustrated that there's no live chat because we're going to need to edit out the beginning so that it's a smooth experience, they're going to be real bummed. I'm sorry. We do the best we can to do the YouTube-y things. I don't know which, I can't do the like Gen Z heart. I'm still like, heart hands. All right. Let us see if we have any more discussion at the end of the morning about scheduling. Let's move away from the bright yellow. There's too much yellow in this courtroom. The yellow legal pad and then the old books. Let's see if we have any more date discussion because I want to know. Let's see. Oh, my sound is not.
When are you available for the Rules 17?
My sound is not gained up. Let me gain this up a little and zoom.
How about November 26th?
All right. We have lots of discussion here. Let me zoom past that. Oh, let's zoom. All right. Let's zoom past this a little bit until we get back to the day they started with.
May I inquire, do I send notice? Yes.
Lally's like,
We'll make the 26th work.
okay.
Great.
I likely will not be here, but she will be represented.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m. on
Get
the
all the
26th.
record holders who want to be here.
We love 10 a.m.
10 a.m. on the 26th.
All right.
All right. And all the other motions are taken under advisement.
Great.
All right.
Okay.
I mean, that's basically
Thank
it.
you very much.
Thank you.
All rise for the court, please.
I don't understand why vigorously cut the cameras when the court is taking things under advisement. We know the judge is taking things under advisement. She always takes things under advisement. I'm going to leave this as court exits. I'm going to just turn the volume down a little bit.
You have a minute?
Yes, Lally does look a little deflated. It's got to be hard no longer being lead counsel. I always appreciate seeing who's in the gallery. This is a much larger court with a larger gallery, but we're going to be covering all of this for sure. So Mellon said, and then we'll get to some Q&A, and then I'm going to go take a nap. Mellon said, my fingers can't do the Gen Z heart. I can't either. Where was it? I hope you cover the Richens hearing. I'm working on getting video. Either way, I'm going to cover it. I attended the hearing yesterday. via audio. So either way, I'm going to cover it. The court has a very strict policy. The audio access is not to be shared in any way. So I will either share or I will share video or a combination of both. We're going to go over everything that happened in Corey Richens yesterday. So we'll do that. Diana asks, what's the Gen Z heart? My fingers can't do it. Like my fingers can't do it. It's a whole different type of, it's not heart hands, it's heart fingers. And it feels like throwing signs from the 90s. So my fingers don't do it. And then, all right, well, we got an extra 30 seconds. It was definitely worth it to me. Hopefully it was worth it to you. Let's go to Q&A. Let's try to do a bit of a summary and go to Q&A. I mean, I feel like there's nothing to summarize with this court because it's like, the judge took things under advisement. Shocking. Oh, I got a new Starbucks cup to go with my Lawnard cup. I say it's research because if we're going to release another tumbler, the way that this one is cut, it kind of speaks to my heart and it is not as spiky. So for those of you that the spikies on these tumblers don't like the way they feel, then we've got a new option. They're incredibly pretty. So did I need another cup? No. Are they for research? Yes. They are for research purposes. Research purposes. All right, let me get us a summary the best I can. All right, what do we need? We need lip gloss. We need lip gloss. Yes, my tumbler matches my nails. Look, I needed nails to go to the concert this weekend. We can talk about it if you want to. Emily, did you cry? Yes. Yes, I did. But yes, it was a vibe. It was definitely a vibe. So I wanted to use the purple glitter this time. I wanted to feel a little more rock star. Don't worry. For the rest of the fall, my nails will probably be black and or Linkin Park After Dark. Why? Because it is my favorite color in the history of the world. And then I always rotate my hollow tacos on my toesies. So let's see if I can summarize. We'll get to some Q&A and then we'll go from there. But we will drop, the podcast normally goes live in about 5 minutes. It's going to drop a little bit later and we will redirect this stream to the podcast. So let us do the briefest of summaries, shall we? So today we were back in court in Massachusetts, back with Judge C or Judge Cannoni, who's presiding over the Karen Reed case. She is now specially assigned to that case. We saw that filing on the docket because it seems that the judges in Massachusetts rotate, which kind of boggles my mind, but rotate between sitting in criminal assignments and sitting in civil assignments. So a case needs to be specially assigned to that judge. So it follows them no matter what type of assignment they are sitting in, which would be very hard, I think, to shift your brain between civil procedure and criminal procedure. I think it would be incredibly difficult, but she is specially assigned to this case. The defense way down the road made motions to remove the judge. That is incredibly unlikely to happen. We're not going to see, maybe we'll see another change of venue motion. It's unlikely we'll see that granted. It is getting too close to the wire. The judge, as she does, took all of the motions under submission, which means there will be written orders on all of the motions that were heard today, including the motion to continue the trial. Currently, the trial is set for January 27th, 2025. The defense and prosecution have asked together that the trial be moved out till April. The new prosecutor was in court today, so it's the first time we've seen Special Prosecutor Brennan in court arguing for the extensive motions that they are doing or that they covered today. They did not argue over the Commonwealth's motion that I talk about in today's podcast to try to get notes from one of the journalists who interviewed Karen Reed. I expect that we will see more motions to get to the raw materials from Karen Reed's interviews because this prosecution team wants to use what she said in interviews against her in court if they can. Remember, what Karen Reed says to an interviewer is not hearsay because it's being offered by the Commonwealth. So when I said, ooh, these make me nervous, these interviews make me nervous, they do. And the prosecution wants to get to all that information. I break all that down in today's episode of The Emily Show. But that was not discussed today or taken under advisement. The motion to continue was the Commonwealth's notice with regard to a new expert and retesting of the Lexus electronics systems, infotainment, telematics, things, all of the technical parts of the vehicle. They are going to try to reassemble and retest. We heard argument over what was going on with the system and why they think they can retest, and how when Trooper Paul extracted it the first time, he didn't really know how to read it, and that reading came out wrong. And they also talked about how they're going to quality control that to make sure nothing's changed in the data that's being downloaded, and giving the defense a heads up so their expert can observe that process and then have access to both the raw data and the conclusion. They also discussed whether there will be ongoing discovery motions, the Rule 17 motions. Those have been put out till another date at the end of November. And then they're putting out the Dauber motions, or motions over the experts, until the beginning of December. So we will see continuing motions leading up to this. I imagine, based on the questions, the judge will grant the continuance. I would be surprised if she didn't. I think the prosecution went a long way to try to speak to the judge directly, saying, we are working on cutting down the witness list significantly. We are working on making this a smoother trial, a cleaner presentation of evidence. We are working on really making sure that we can do this better, faster, but also said, of course, Your Honor, I will be ready if the court wants me to be ready in January. But I think a fair trial requires additional time for everyone to have this information and the new experts that the Commonwealth is bringing in and that the defense may need to bring in. So telling the judge it's going to be smoother and faster and less witnesses, I think speaks directly to the judge's best interest as well in operating a smooth courtroom and having jurors there for a shorter amount of time. For the defense, they're not asking that continuance be denied. The defense is on board with it, saying, yes, we want this information too. We want the digital information from Karen Reed's car. It might very well benefit them. We've seen defense make statements to the media that they do not believe the state's case. They do not believe Karen Reed did this. And if the defense has the best position to know what should be on Karen Reed's car based on their conversations with Karen Reed. So I'm not surprised that the defense is not arguing about the continuance. And I wonder if when that information comes in, if the defense will be advocating again to narrow down the charges in this case. Is it unlikely? Yes. But is it something that they can ask for? Also, yes. And of course, we're going to see the judge's rulings probably next week, maybe a little longer, but the judge seems to be ready to move things along. That might shift if a continuance is granted, though she did set these motions in anticipation of a January trial. She didn't say, all right, well, let's set these motions in January. She said, we need to do these immediately. So she's denied continuances in the past. I've been surprised each time she denied a continuance. So it would surprise me. I mean, does anything surprise me at this point? It would surprise me if she denied the continuance. Then again, it would be keeping in line with her prior rulings in this case, being like, nah, I just want to be done. Let's get this done in January. So we will see what this judge decides to do in those written rulings. And now we're going to get to questions. You've got questions, I've got questions, and we're going to see what lasts first, or what we run out of first, my steam or your questions, or maybe the day quote will just kick in. Oh, that was me cutting myself off while I was talking with the finger on the button. Yes, it was. Yes, it was. It's time for questions. It's time for questions. You've got questions. I've got questions. I've got cold medicine. We had coffee. There's water. It's all gonna be fine. That was entirely me. Big Dog 5758 said, replay crew today feel better. Look, hopefully the replay crew is a smoother experience than this morning, because God in heaven, look, this morning was like, we're going to see how much you really want to stream. And if you guys listen to the podcast today, I have some exciting announcements in the podcast. But there's days it's like, are you sure that interactive is what you love? Yes, because things go wrong and we just fix it. Kira, congratulations on 24 months as a law nerd. It's so good to see you guys in the chat. Leah says, so thankful for a stream today. Is a crappy paw nerd mom day. I'm so sorry. We've had some paw nerd loss in the Team Baker family as well. It is incredibly difficult, but I'm sorry, it is a hard day. It is a hard day when the pets don't feel well. Rachel said, don't apologize. You're doing great. Thank you all for you're doing amazing, sweetie. Look, we try our best. Things don't always go well. It's what I love about streaming. It is so for real, because things don't always go smoothly. There are days that you turn on your computer and it's like, it's going to take me 4 hours to update. And you're like, well, great. That's the day. That's fantastic. Things are not smooth. Life is not smooth. We all do the best that we can. We don't strive for perfection here. We strive for making things work. And, that is a lesson I think that we all can take away, is that nothing will be smooth. Nothing works perfectly. And it's so much easier when it's edited. When you see edited YouTube videos, there's multiple takes. It's why I like doing the behind the scenes with our members, both in the Law Nerd Lounge and here on YouTube, because you get to see me be like, no, I can restate that better. No, let me retake this. You get to see my process of thinking, and it's just what it is. Brandy Rose, good to see you. EDBM mods, not sure if this is helpful, but even the break audio was crackling. It is helpful. And when we that was a browser plus StreamYard not playing nicely issue. And to be completely candid, we had a call. It takes a while sometimes, but we actually were able to get on a call with StreamYard and show them the issues that we were having. And they're like, okay, it's all solved now. And then a week and a half later, 2 weeks later, it's back to not being solved. How do the things that are solved get unsolved? What? Sandra asked, good question, Sandra. I wonder if Karen is still working. I covered at length last week the Vanity Fair interview. And in that interview, it indicated that she was not working and had not been working for quite a while, and has over $5 million in outstanding legal and expert fees and bills. So no, she is not still working. And that is also difficult. With this pending, it would be so hard to try to work. So no, not still working. Brittany, that raccoon queen, said, hear ye, hear ye. We are back in Massachusetts, law nerds. Look, it's my favorite thing. It's my favorite thing. I want all courts to start with hear ye, hear ye. I love the further affiant saith not. Like, there are some traditions in different states that I find absolutely delightful. It is interesting to see how the legal system, I'm a nerd, so for me, it's interesting. Hopefully it's interesting for you as well. But it's interesting to see the more English tradition of law, the way it impacts the East Coast differently than the way it impacts the middle of the country and the West Coast. The law, as you go across the country and as you look at the kind of the founding of the country, you can see the way that those traditions shifted and changed and moved. When we're in Idaho talking about the old field codes and California law, that law is not as much of an English tradition that we see in the original 13 in the East Coast. You see much more common law English tradition in those states than you see as you move west. It's a very interesting thing to see how the history plays out and then how the founding of our system plays out across the states. I find it fascinating. But again, when you look at the U.S. legal system, a lot of the U.S. legal system is like, we don't want to do it that way. We don't want to do it that way. It's like, take the British system or take the English tradition and go, yes to this, no to this, yes to this, no to that. And then you see how that plays out. I think it's very, very interesting to see the way that those traditions carry out or don't in the different systems. Though no one wears wigs, which I am told are very expensive. And so there's that. I'm kind of glad. So it shifts again as you go across the country, and we learn so much about the practice of law elsewhere. And then even in different courts, we saw the Supreme Judicial Court also start with hear ye, but they refer to co-counsel and opposing counsel as my brother, which is wild to me. Anon Mouse says, in Canada, our lawyers still wear robes, and your Supreme Court looks like Santa. And I love it. The Supreme Court's got the red robes with like the fur. It's just not the boots with the fur. Maybe there are boots with the fur under the red coats, or the red robes. Not Emily being like, the British are coming. No, the red robes. It's just fascinating to see how those traditions grow and shift based on history. There's a lot of the historical side of the legal systems I find to be fascinating. But anyway, I digress. Yes, the judges should all have the apple bottom jeans under the robes. Look, judges can be very casual under their robes. There was a judge until he pissed off the wrong one. I want to talk about lawyers getting petty. There was a judge that I had worked in front of until he pissed off the wrong one and she ran against him and won his seat. It was like, fine, I will come for your full ass job, but wore like Under Armour shirts and stuff under his robes. So would come out on the bench in the robes and then would be like ready to go work out at the lunch break. So it's interesting to see the way that judges choose to dress in their robes. It's always courthouse appropriate, but it is varying levels. So when we were in Idaho, and people are like, wait, is the judge wearing like jeans under his robe? Probably. So Kelly said, do they have to wear something under their robes? Probably. Courtrooms are disgusting. So you would absolutely want to. So that courtrooms are not, I wouldn't. Also, they don't wash their robes as often because they are an overcoat. Miguelina, I will let you know as I know when I am wrapping up, but it's probably going to be 11:30 that we might bump it back. Kate B said, I'm so sick, Emily, and chilling with the law nerds while snuggling with my paw nerd. Kate, I get it. Honestly, I am also struggling. I am not so sick. If I was so sick, I would not be streaming. I am not great. I spent most of the day yesterday mobile gaming and sleeping. And then I was like, I'm going to do a podcast. And in court, that's true. That the Corey Richins hearing did take up a substantial part of the morning. I'd already like blanked, but it was interesting. So all of the things. Also, I was late to the Corey Richins hearing because I keep forgetting that Utah is not in fact Pacific Standard Time, but I also am working on getting the rest of the video from the hearing, but have the first part that I missed. So that is good. The pool provider has been fantastic. So True Crime Hockey Mom said, good morning, EDB and Law Nerds. I officially feel like a law nerd now. Monday was my birthday and I just got the Law Nerd Tumblr and I love it. Happy birthday, True Crime Hockey Mom. And I'm glad that you love it. The tumblers are gone now. The Law Nerd Shop 1.0 is gone. She is into the vault. And I make a joke because for those of us that are my age, Disney used to release movies onto like VHS and then they would go back into the vault. So if you didn't get like The Fox and the Hound or Robin Hood, the one with the foxes, when it was out of the vault, then it would go back into the vault and there was no way to get it. My kids have no idea what that means. They're like, it's just on Disney Plus. I'm like, you don't understand. You don't understand when movies were released. If you did not have it on VHS or didn't grab it so you could go to Blockbuster or whatever, they went back into the vault and there was no option. And for kids, we used to rewatch like day after day after day the same handful of movies because nothing was streaming. My kids don't even get it. They're like, what do you mean? I'm like, there were like 6 movies we had on VHS and we just watched those because there was nothing on TV we wanted to watch. And the commercial breaks seemed longer. And that was it. Nicole said, wish us luck at BOA Grand Nationals from Utah. Congratulations, Nicole, to you and your band, Nerd. You guys are going to be out here. They're in Indianapolis, aren't they? So good luck at Grand Nationals. Is that this weekend? I think that's this weekend. So good luck at BOA Grand Nationals. What an incredible thing. I know a lot of the DCI groups are having like tryouts and stuff there as well. Emily, where's your brain? Oh, it's DCI. We've gone from Bandtober to DCI tryout season into Winter Guard season. So my brain is constantly in band mom world. Rachel said, if Judge C denies the continuance, does that create an appellate issue since it was requested by both sides? No, not really. They knew it's a retrial. They would like to do things, but they don't have to. And the denial of the continuance before did not create an appellant issue. Both sides have asked for continuances in this case numerous times, and she's denied them. It always surprises me, but she does. Twin Mom said, can we get music food court when you're better? We just did a food court, so it's going to be a minute before we get another one. I've been needing to do music court, and things have been popping off so fast in some of the other cases. And popping off in connection with hearings, that those have taken priority, but a music court is going to happen, whether it is a live or whether it is a upcoming podcast episode. But yes, we have lots of music court to cover. I have a list. We have lots of music court, but there are a ton of motions in the Corey Richards case. There's motions. We haven't read all the motions in the Karen Reed case. So no matter what the judge rules, some of those will go over together. There's a bunch of motions in the Diddy case. I summarized some of those today. I think I forgot to talk about some of the judges' rulings today. We'll get to it on Thursday, maybe. Addison said, got my I Have Questions hoodie last night. So comfy. I'm so glad. Look, for those of you that are ready for Law Nerd Shop 2.0, if you go to, I can't read that. If you head to the Law Nerd Shop now, you can sign up to get notified when the new shop goes live. You can see some of the new logos. So should I show everybody? Let me show everybody. Why won't it type over on this window? Come here. No, it absolutely won't. That's so strange. All right. 30 seconds. I'll give you guys a little peek. The members got a little bit of a sneak peek on the Law Nerd Shop. So let me pull this up so you can see. But if you want to know when the Law Nerd Shop goes live, you should be able to see it. This doesn't want to pull up for me. And that's a computer me issue. So let's pull that up and show you guys. So if you want to be first to notified, well, members get priority. So the members will get a sneak peek and some early access. But I understand not everybody can be a member. Look, the new Law Nerd Shop 2.0 is coming. If you want to get notified, you can sign up with your email. You can also download the app. Those are the things that you can do. This is our new Law Nerd Love logo for the Law Nerd Shop. So I'm very excited. We've got a whole new look and feel. We've got merch drops planned out for the next couple of quarters. I am so excited for this drop. We also have the next drop planned. I am so excited to bring you guys stuff that we have been able to custom curate even better. It has definitely been a labor of love, but I am so ready. I am so ready. So all of the things, all right, all of the new things. Brooke J said, oh my God, I didn't know you were a Holo Taco lady. Hello, Brooke. I am. This is in the background. This is a Holo Taco box. That is a Holo Taco box. That one's a Holo Taco box. I need to do a members only tour because I'm considering also a little bit of an office refresh, but that is a Holo Taco box. Yes, I love, I think Christine over at Simply Nailogical is incredible. Love the podcast. Loved the nail streams. I'm an OG fan, but also love what she's created and love supporting her business. And also she has been very generous to put me on their PR. So I've gotten to try so many things. It gets a little harder to send PR back. All of you Canadians know how difficult it is to send stuff back to Canada. She sent me her tea collab. I have been meaning to post that on social and I'm going to because I love it. So that's what we're going to be doing later. All right. Kara said, question, do we know if she had contact with the kids, has had contact with the kids? So based on the Vanity Fair article, it seems that Karen has not had contact with the kids since the day that this happened. So J.A. Williams Dorr said, home recovering from a broken ankle. That is not easy. That is not easy at all. So recover well, keep it elevated, and hopefully you have someone to bring you the things that you need so you feel better. Let's see. Elias said, on a lighter note, a meme informed me that we are going backwards technologically. We don't call, we text. I feel like we have gone a little backwards. Like calling somebody out of the blue without the hey, are you free now? Feels very strange. I always have my phone on do not disturb unless I have a call time set. And now it is let's set a time to call. Question, did you hear that Canton police is being audited? Do you think that could impact the case? I'm not surprised. I don't know exactly what we mean by audited, but we do know there's been investigations into numerous officers. I wouldn't be surprised if there's an an overhaul taking a place at Canton. I think this is the one that Canton PD decided to do on their own. But yeah, there are some questions. Look, there are some questions. KW metal, we had metal travel mugs, but it is definitely on my mind as we get into future drops, in addition to coffee mugs and ceramics and glass, but it is definitely on my mind. It won't look like these. These only are plastic, but yes, more non-plastic options are on the list. But we did have the metal travel mug in the store 1.0, and we had a metal stainless steel water bottle that was in the store. Music to My Soul said, Judge Beb, Mr. Jackson, you can't, why can't you fly by EDB Air? Exactly. Why can't you? Angela Whitaker, good to see you in the chat, said, hung out with a friend I don't see very often on Saturday. Found out he is also a law nerd and watches you. Well, now you guys get to chat in the chat together, which I love because so many of you do with friends and family, no matter where you are. Valerie said, why can't the Daubert expert on Zoom and save expenses? I don't know. But apparently that's not happening, so they are not. What's really interesting to me is when Corey Richins was doing the hearings, they were talking about doing jury selection via Zoom and whether jury selection would be in person or not in person. And there was a lot of back and forth about it. And I was like, how do the lawyers even do jury selection by Zoom? Like, that's wild to me. But different jurisdictions do different things. And that courthouse seems to be a bit more remote. And the judge is like, no, that's how we've been doing it here. I'm like, what? By Zoom? Jury selection? Like the jurors are on Zoom? Wild to me. But apparently that's what they've been doing in a lot of Utah. So Steph said, I'm off today and it's my birthday. Happy birthday. So happy we're restraining today. Hope you feel better. I mean, today seemed, other than tech, fairly smooth. Stephanie said, please let Alan know we love the facial hair. I'm sure he will be advised that the law nerds are 10 out of 10 fans of the beard. I'm sure he is aware. Carrie said, went to the law nerd shop for the first time and got the 2-for-1 tumblers. I wanted one for ages. Thank you so much. You're welcome. I'm glad you did. So thank you. Steven said, you're doing great, sweetie. I appreciate it. I always need that. You're doing amazing, sweetie. Especially when there's tech issues. It's like, what? Kit said 2 years. Love that no one is staring laser daggers at Karen and the defense team today. Yeah, it seemed that the court layout works really well for that. So it's fantastic. Let's see. It's me, Rachel said, as someone who gets sick often, I prefer Alka-Seltzer Cold over Dayquil or Advil Sinus. That's good to know. I'll give it a try. I'm here for it. I've been, I use a lot of different nasal rinses, which helps me quite a bit. So that's what I was doing this morning, and that's what I'll do after this. I don't, decongestants don't always help. It's fall. My kids have been sick. I have what they have. I hope I said that right, Sayla. EDB, will this new merch include those Pokemon type cards for each trial? I'm so that kind of law nerd. We have something for you on that when there is a new launch. So I will keep you in the loop. We have a limited edition of cards that we have created. They're not for each trial, but we have some law nerd specific collectible cards that we will announce with the new. So do not worry. We have something for you. They were much more difficult to produce than we anticipated. This is the problem with Team Law Nerd. Team Law Nerd's like, this sounds like a great idea. And then generally somebody's like, yeah, we can do that. And then we get midway through and go, oh, this is much more complex than we anticipated, but we do it anyway. Whitney said, have you ever covered a case in North Carolina? No, we've only done South Carolina so far. But we need a map. We need like a Law Nerd map of where we've done trials, because we're making our way. I mean, I think Alaska's going to be tough. But we'll find something. Alaska's going to be tough because the pool cameras are going to be like, yeah, I don't know if we're going to travel there to get camera coverage. So we will see. Irish Rover said, isn't this confirming that they messed up the investigation from the start? I think fresh eyes help. I think after the first trial, much can be learned with a fresh view on the trial. And I think that's what the new special prosecutor is doing, but their experts weren't great. I don't think that's a secret, or at least that's my opinion. I don't think the state's experts were well prepared or persuasive. I think that the Fed experts, the biomechanical engineers, were some of the best experts in the trial. I thought that the different pathologists were very clear, but they were very clear. So I think that the state has to find a way to have fantastic experts make what they're saying happen make sense, because based on the expert testimony I saw, the way the state says things went down is not what the evidence shows. So I'm interested to see how they try to do that. But the evidence is the evidence. And at the end of the day, the biomechanical engineers looked at the vehicle and looked at the autopsy and went, that's not how that happened. So I think that's really, how does a jury overcome that? How does a jury overcome something happened? Clearly. But what is it? I don't know. If the prosecution can't clearly tell the jury what happened, I think that just leaves doubt. That's my opinion. And I know not everybody agrees. It doesn't mean that something didn't happen. Something clearly did. It doesn't mean that Karen Reed wasn't involved with it. She may well have been. It means that we simply, from my perspective, simply don't know enough to have answers. And if there are not answers, to me, that is doubt. And to me, that makes it very hard for a jury to overcome that. Do I think that there was drinking? Yes. Was everybody drinking and driving that night? Seems like it was. Did something happen to John O'Keefe? Yes. And he and his family deserve to know what happened. I just don't think we're there yet. I was hoping that trial would bring more answers. And for me, it brought more questions. Sprock said Law Nerd Team jerseys would die for a purple one. That is a great idea. That is a great idea. Chibi, I never ask people to do collabs like that, especially when they're product, because they decide products so far in advance. I love that we have a great relationship, and we will see down the road, but it's not something that Holo Taco does a ton, and it's not something where I would even be like, we should totally do this. If that's something Christine would ever be interested in, then we would talk. But I just enjoy being a fan, which is perfect for me. Jesse said, looking forward to the shop reopening. I totally need another hoodie, of course. And they are the custom dyed hoodies that we have coming are so excited. I'm so excited. Jessica said, it's always a beautiful day when I'm with y'all. Jessica, it's good to see you guys too. And look, we're riding through on excitement. At this point, we're just riding through on dopamine of going to live court. Would I have streamed today if we didn't have live court? Probably not, because my brain. Contenta, I think I got that right. 1979. 1799. No, 1979. The Vault. Thank you for explaining that to a 1-year-old. Had to search for Disney Tarzan at all thrift stores after the VHS broke. Yeah, it's so difficult. It's so difficult. My kids just don't get it at all. It's me, Rachel said, do you think we will see a jury poll this trial regardless of outcome? Yes, I do. If there is a second trial, if the jury comes back with anything, I think the jury will be polled. I do. Melody said, what if newfound data supports the defense? Will they dismiss? I don't know what the prosecution will do. That is a possibility. It is a possibility that the case gets worse for them, but the goal of the prosecution should be to find answers and the truth, no matter which direction it leads. So if that's the direction it leads, I would hope that they would. If it comes back with irrefutable evidence, I hope that they would. So, Law Nerd Soph said reducing the witness list because half of them are in trouble with the FBI. I mean, the FBI. Maybe. But they're going to have to bring in some of those experts because the defense is going to bring in some of those experts. And sometimes it's going to be interesting to see the strategy here. If the prosecution brings out all of the negative or lets the defense just do it. I'm curious to see what the strategy will be. Fala said, didn't she make them remark everything, or was that another trial? Oh, that is different. Fala, that is a great question. So what Fala's asking about is that didn't Judge Bev make them remark all the exhibits? Yes, the exhibits had been pre-marked for trial, And then Judge Bev made them remark them for trial, but those are just the trial exhibits. The discovery, all the discovery should be marked between the defense and the prosecution, which would have made the remarking maybe not as difficult or maybe more difficult, because it would have been, Bates stamp, whatever, is pre-marked as 1, as remarked as 10. It would be 3 numbers. But yes, she did make them remark. She told them they could pre-mark the exhibits, but the prosecution wasn't particularly organized. And so when they were admitting exhibits, some of them were out of order from how they were pre-marked. And the judge was like, no, I want them in order as they are being introduced. Sometimes when you pre-mark exhibits, it's like pre-marked exhibit 7 gets introduced second, but you can just admit it as people 7, knowing the others will come in. But I do think that made things more difficult. And I think that was the judge making things more difficult. If she had said no pre-marking, then they just wouldn't have pre-marked anything. But Brittany in the chat said, wait, prosecutors don't normally have a paralegal. I have not seen a prosecutor's office where each prosecutor has a paralegal, or even groups of prosecutors have a paralegal. Sometimes the office will have 1 or 2 paralegals or research attorneys they can work with. But in a lot of the offices in the office I've worked at and with others that I know, most agencies did not, again, things can change, did not have paralegals. They sometimes had research attorneys, sometimes had interns, but often did not have paralegals. So when I needed to copy exhibits for the court, I did it. When I needed to send out subpoenas, I got them all ready and then had assistance in getting them sent out by our investigators, but I did that myself. When I needed to get ready for trial, it was on me, but it really varies by office and how many attorneys are in the office. So it really, really will vary. But no, not all offices have paralegals. Not all offices even have paralegals for pools of attorneys. So it really just depends. So, yeah. Though that should change, paralegals would definitely help with offices, and you don't need everyone in an office to go into court. I have a lot of thoughts about how things could be run better. But again, every jurisdiction does it differently. Clint said, in a new trial, if a witness from the previous trial is not called, can the attorneys use their testimony from the previous trial as evidence? Not without the witness. So they would have to have the witness come in, but either side can call the witness. So it really just depends. Kara asked, do we know if she has any contact with the kids? I talked about that. We saw that from the Vanity Fair article. It seems like no. Rolling Hills said, like new prosecutor, AJ's beard is thumbs up, no shave November. Yep. My kid is trying to do no shave November, but he's so blonde that his friends are like, are you shaving? He's like, no, I'm just blonde and 16. Aleda, I think I pronounced that right. Why would an attorney ask for a special prosecution prosecutor? So, excuse me. We went through that article. Was it Thursday last week that we just streamed for 100 years? We went through the article, and it seems that nobody inside the prosecution's office wanted to take this case. Color me surprised. And that the decision was made that Lally would not be the one retrying the case. I think the case can be done better and more streamlined. I also, this is my own, suspicion or my own personal thoughts on this. I wonder if Lally was too close to the case. Sometimes you need an outside perspective. It seemed like Lally was really involved in this case from early on in the investigation. And sometimes you just can't see the blind spots. Like when you're so convinced of a thing, and this happens in all kinds of things. When you're like convinced of a thing, it's real hard to see where people might not be on the same page with you. Sometimes you need someone to take a step back and be able to look at it with fresh eyes. It's like if you're trying to edit something that you've been working on forever, and all of a sudden you can't even see the edits because you've looked at it so much, you can get blind to a thing. And I just wonder if Lally had been so closely involved that he doesn't see where jurors might have issues with some of the witnesses, with some of the evidence, with some of the experts. it would be hard. Also, I don't think he should have been the only one questioning witnesses. He needed more support in trial. And so it gets difficult. I think they needed fresh eyes. I really do. I think we needed fresh eyes on this case. And we'll see what happens when fresh eyes are on this case. Charlotte said, hi, got a brand new ADHD diagnosis at 68 years old. Understand my life finally. Look, I am all for the more we understand, the easier it is. I am so excited for you, Charlotte, and congratulations. And I'm glad you were just like, now we know. And it's hard. ADHD in women can be different. It can present differently. Like all things, most studies originally were done on men, and then they just tried to extrapolate it. And it's like, okay, our bodies go through lots of changes. So it's very helpful to now have people start to recognize how things show up differently for different folks, and maybe starting to widen that lens of how they look at things. And I'm glad, because it's nice when it feels like it makes sense. Oh, did you guys see yesterday? I'm going to answer like 2 more questions and then we're going to move forward. And then we'll know. Then I'm going to go rest. That's not true. I have a meeting. What time do I have a meeting? Darn it. I have a thing soon. We're going to need to premiere the podcast soon, because I forgot I have a YouTube thing. Oh, at noon. I got to get Chad, I got to get scooting. I got a YouTube thing. Did you guys see that My Chemical Romance is going back out on tour? The way I yelped yesterday that MCR is going back out on tour. Music to My Soul said, if Lally didn't want to retry the case, then why is he still on the team? I don't know that Lally didn't want to retry the case. I think the office wanted somebody else to look at it. So tickets go on sale tomorrow. Miguelina for 11:45, please. So like 10 minutes from now ish. So yes, MCR tickets go on sale. I'm so excited. And on one of the stops in Florida, they're opening with Evanescence. Oh my God, I'm so excited. I'm so excited. The openers on the tour look so good. Like, how do you pick just one? Like, how do you pick just one tour? Also, my kiddo and I am not huge festival people. So when we look at like when we were young and stuff, it gives me a whole lot of social anxiety. But yeah. Anyway, Octo's like, I love how you were like, I have to leave anyway. MCR is going back on tour. I know. Anyway, I love it so much. So look, I will tell you what, I promise we'll get to like 2 more questions. I took my kid, my teen, who was very interested, because I was asked, wait, was this your decision or your teen's decision? My teen, Dr. B, and I went to go see Creed in Nashville. I didn't realize Scott Stapp was living in Nashville now, and I didn't realize that 3 Doors Down is also local. So it was like a full-on hometown show here in Nashville with Creed and 3 Doors Down. It was so much fun. We had such a good time. They play With Arms Wide Open. As my kid is singing, I just start bawling. I'm like, this is like, my kid wants to come to concerts with me. It's like the thing that I enjoy so much, that he is starting to enjoy so much. It was just so fun to be able to share the excitement with him. He is so excited about MCR. I am so excited about MCR and taking him to see MCR. I'm so excited. Look, we have tickets for Metallica. I feel like I'm getting to share really what is my favorite hobby with my kiddo, and we get to do it together. I just am so excited. I'm so excited. Live music gives me life. So when we moved to Music City, I was like, this is it. We're going to see all of the concerts. My cat's name is Karen. MCR is coming to Florida. Yes, they are. So now I'm trying to look at our summer. This is when calendaring gets complicated. I'm looking at my kid's schedule and trying to navigate his schedule, plus maybe taking him out of school for a day to see MCR. Am I that parent? Yes. Will I take my kid out of school for experiences that might be their opportunity to do the thing? Yes, go see the band. Skoda, we're also going to go see Deftones. So yes. Why? Because one of my largest regrets in life is that I never saw Oingo Boingo live. The regret that I have never seeing Oingo Boingo live. Look, I saw The Offspring live in the 90s. My bestie Chris and I thought we were going to die, and we went and hid in the seats. We didn't realize that because we were early, where we were standing was super exciting, and that a pit would begin. It was my first concert that was like that, you know, beyond the like Paula Abdul pop kind of concert. And so the second the pit started, we're like, we're going to die. Run away. But those experiences are needed. Live music has gotten so expensive, but one of my greatest regrets, not seeing Oingo Boingo. I am going to, if I can do anything as a parent, through working hard, it is making sure my kid has some of those experiences and getting to see some of the bands that truly he loves and he might not get to see down the road. So, and the college tours, I mean, when I was in college, every band would come through the colleges and tickets were like $20. It was just so good. Jenny said, I saw Oingo Boingo at the Greek One tickets on K-Rock. Oh my God, life. So live music does good things for the brain. Just Chloe said, do you think the defense will use the same expert? Yes, for some things. And I think they'll get new ones depending on what the state does. Replaying at 1.5 speed. Look, I'm slow today, so 1.5 probably works because I'm not talking as fast as I normally do because sick. Ken said, what are the chances the prosecution comes up with an entirely new theory? They might. Potential jurors would supposedly not know about the first theory. They might, but I don't know what. I'm going to run this through my brain and process out loud. At the core of their case, their theory is Karen Reed hit John O'Keefe. That has to be the core of their case, or they don't get to some of the charges that they have. It's beyond Karen Reed let him out of the car and negligently left him in the snow. It's beyond that. It has to be. So I don't know what they're going to do with that. Chat, I am going to have to bounce. I will be in and out of the live chat for the podcast premiere. I have some exciting content announcements at the beginning of the podcast. We talk a bit about Diddy. We talk about that Karen Reed motion with the prosecutors trying to get after the media, and a little bit about Corey Richins. I will hopefully be back tomorrow. I am optimistic, but if I feel worse, then we'll figure it out and I will let you know in the Lawnerd app. Go hang out in the premiere. This chat's going to redirect to there if you want to keep on chatting about this and others. I will be there with you in and out because I do have a talk that I'm giving with YouTube for some newer creators about channel membership. So I've got to go do that and be all like, I'm going to just be like this. This is what we're going to just do this. Lawnerds, it's good to see you. Thank you. Thank you to everybody for all of your love for the tumblers. I'm glad we could get them to you. I'm excited for what we're rolling out very soon. So Lawnerd Shop 2.0 is coming. Thursday, we will be back. What time? I might, if I'm feeling, well, we'll see. I'm hoping to not shift it back. Planning on 11. Planning on having some video for Corey Richins. And then a breakdown of the hearing and the motions. And I'm excited. I'm excited. I'm excited to be here with you guys. There's a lot coming up in 2025 I'm looking forward to. If this trial starts to overlap Corey Richins, though, we're gonna have to figure that out. I don't know what we're gonna do. We'll figure it out. Lawners, it's great to see you. Thank you for all the member chats. Thank you. Heather, I'm excited that you're optimistic. The Lawners are here. Keep us in the loop, please. And I will talk to all of you soon. And I will see you Thursday. If I shift time around, I'll let you know. All right, go jump into the premiere. I'll see you guys shortly. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Lawnerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Lawnerd.